A Leon County Circuit Court judge ruled against Governor DeSantis' ban on mask mandates in schools last week. Judge John Cooper said that under the law, the defendants did not have the authority for a blanket mandatory ban against face mask policy that does not provide a parental opt-out. They simply do not have that authority. Now, he added, I have heard significant evidence concerning the medical and scientific basics for face mask policies, and I conclude this evidence demonstrates that face mask policies that follow CDC guidance at this point in time are, quote, reasonable. Joining me on the morning show, one of the attorneys for the plaintiffs, Charles Dodson. Good morning.
Good morning, Bruce.
So with this ruling, with the growing number of COVID outbreaks in schools, with the growing number of schools having to move to virtual learning and the threat of sanctions lifted, do you expect more mask mandates on the local level?
Well, certainly that's hard for me to anticipate, but I certainly know that the local school boards now can do that. As long as this order is in effect, they can do this without any worried about being punished the way the governor was threatening to punish them before.
Which was taking away school funding. Now, a spokesperson
Correct.
for the Florida Department of Education echoed the governor's statement, saying the ruling conflicts with parental rights. Well, you do have the issue of personal rights against the common good, according to some people. But that said, don't parents still have an option if there is a legitimate reason for their children not to wear a mask?
Certainly, and I think all of the local school boards that have enacted the mask mandates have provided for medical opt-outs. So if there's a child who has a valid medical reason for not being able to wear a mask, all the parent has to do is to get a doctor to essentially write a note, and that will excuse that child from wearing a mask. So there certainly is an opt-out for medical reasons for children.
So the governor's office said it plans to appeal. Here was their reaction to the ruling. This ruling was made with incoherent justifications, not based on science and facts, not based on the merits of the case as presented. What merits might they be talking about?
I have no idea. They obviously were not listening to the same case that I was listening to and weren't listening to Judge Cooper's ruling. Judge Cooper went through in very great detail, talking about the merits of the case, how this blanket prohibition of mask mandates by the governor was a violation of the Parents' Bill of Rights. The Judge Cooper went through the medical evidence, went through all the scientific evidence, went through the state of COVID as it stands in Florida right now with the Delta variant, and very thoroughly discussed the merits of the case and the law. And I think he had a very sound basis for his ruling, and he made sure that when he explained it on Friday, that he explained it very thoroughly.
So the governor's office also made much of what they called the political question defense, which intimates to me that this had to do a lot with politics. Doesn't that hold much sway with the court? And if that's the case, won't the entire Amendment 9 come up in any appeal and subsequent argument?
Well, Judge Cooper also thoroughly discussed the political question defense, and what he made very clear was it's really not a political question if the judge does something, if the governor does something he doesn't have authority to do. The judge said that he greatly overstepped his authority by doing this in violation of the Parents' Bill of Rights, which they were basically basing the order on. That Parents' Bill of Rights went into effect on July 30. And the judge did a thorough analysis of the Parents' Bill of Rights and said that because the Parents' Bill of Rights says that parents have a fundamental right to exercise full authority over their children's health care and education, that the government can only infringe upon that. And this is where Judge Cooper found these local school board provisions to be proper. A local school board can only infringe on that right if they have a reasonable and necessary basis to achieve a compelling state interest, and it's narrowly drawn to do that. Well, certainly in this case, given the status of the Delta variant and how contagious it is and how much more it's affecting children, they were able to show a reasonable and necessary basis to achieve a compelling state interest, which would be to slow the spread of COVID and the Delta variant. And it was drawn very narrowly. It said that we'll have opt-outs for children for medical reasons. So I don't know that Amendment 9, the education amendment in the Constitution, might not even be discussed very much by the appellate court, because what Judge Cooper found was that that provision of Amendment 9 that says that we've got a duty to provide safe schools for children, that's not in question in this case. That was ruled on last year by the First District Court of Appeal in the FEA versus DeSantis case. And Judge Cooper did not find this to be in violation of the provision in Article 9 that requires safe schools. He didn't want to rule on the Home Rule Amendment that says that local school boards have the authority to operate, control, and supervise the local schools, because he said the case law is pretty unclear on that. But he did find that the governor violated the Parents' Bill of Rights, and what the governor's order was arbitrary and capricious. And so I don't know that the appellate court will have to discuss very much Amendment 9 when they get into to Judge Cooper's ruling.
Charlie Dodson, appreciate your perspective, and thanks for spending some time with us. Have a great day.
You're sure welcome. Thanks.